Hey, folks, welcome. Glad to have you with us. Glad to be with you. Let me just start by reintroducing my guest. It is Roger Pilon. He is the founder and director of the Cato Institute's Center for Constitutional Studies. That, by the way, has become a really important force in the national debate over constitutional interpretation and judicial philosophy. He's the publisher of the Cato Supreme Court Review and an adjunct professor of government at Georgetown University. I've known him for years. He is just outstanding in his ability to teach about the Constitution and the Federalist Papers and frankly, the benefits of liberty. So we've spent the first hour of the program today talking about the Federalist Papers. And as we got to the end of the hour, we were talking about the doctrine of enumerated powers, which specifically says to the federal government, here's what you can do. Because they couldn't list everything you could that you were allowed to, that you were free to do. So they said to the federal government, here's the things that you're able to do. This is it. Beyond that, nothing. Apparently, Congress held on to that thought for 100 and some years. They every time they had a bill that called for some kind of a welfare program, and I mean that in the modern traditional sense, not the traditional legal sense, but in the modern sense, legislators would turn it away. They'd say, "This is not our job. It's not here. It's not in the Constitution." And as late as 1887, Roger was saying, a piece of legislation was introduced that was rejected because it didn't fit in the doctrine of enumerated powers. Roger, welcome back. What was that legislation?
Well, okay, we were talking about the doctrine of enumerated powers, the idea that Congress has only 18 enumerated powers, and if you can't find it, it doesn't have it. And I gave you a couple of illustrations from the late 18th century of how the bill never got out of Congress, but then over time, bills did start to get out of Congress, and one that got out in 1887, 100 years after the Constitution was written, was for the relief of farmers in Texas suffering from a drought, the appropriation of a princely sum of $10,000 to buy them seeds. President Cleveland vetoed it, and in his veto message he said, "I cannot find any authorization for this expenditure in the Constitution." Now notice the point that he was making, and in the earlier examples that I gave you where Madison and Giles, congressmen from Virginia, made similar points. In each of these cases, what they were saying is not that this wouldn't be a good thing to do, but simply that we don't have the authority to do it. This isn't our money to spend on anything we want. We have authority to spend only on certain things, and that's it. And so what you learn from this history is how seriously they took the Constitution for a good deal of its history, and how seriously they took their oath of office. In fact, what you see is that most often bills never got out of Congress, or if they did get out, the president would veto them, or if he didn't, the court would find them unconstitutional. Not entirely, to be sure. Government did grow slowly, but very slowly compared to what we have today. In fact, that was true right up until the New Deal. There is a wonderful book that I will recommend to your listeners called, aptly, Congress as Santa Claus. It was written by Charles Warren, who was a professor at Harvard Law School, in 1932, a series of lectures he gave at the University of Virginia Law School in January of that year. In this book, he was lamenting the rise of the welfare state in America. Now, this was before Roosevelt was elected, January of 1932. When we read this book today, we marvel at how he was marveling or lamenting the rise of the welfare state, and it was nothing compared to what we see today. And so the thing that we get from reading this book is how long it took for the welfare state to be resisted, how long the founding generation's ideas about limited government obtained through the history of the United States until the progressive ideas started to take hold, and that was the beginning of the end, and those are the ideas under which we live today. Those are the ideas that have given us modern constitutional law, not to be confused with the Constitution itself.
Roger, would you argue then that for the first, say, 150 years or so of its existence, that we were a libertarian society?
Very much so, but you have to be careful there, because there never has been a golden era of liberty. At some points in our history, some liberties were better protected than others, and so forth. If you're an African American, you're an awfully lot better off today than you were 100 years ago, to say nothing of 200 years ago. By contrast, if economic liberty is your interest, and of course that's an interest that all of us have in one way or another, unless we work for the government, then you would have been better off 100 years ago and even 200 years ago, because there was far less redistribution and regulation in those eras than there is today. So those are just two kinds of rights that we're talking about. Again, First Amendment rights are much better protected today than they were 200 years ago, for example. There were the Alien and Sedition Acts early in our history, to just give you one example. Religious freedom was not always well protected during the early decades of the 19th century. And so we've had always a back and forth on the protection of liberty, but what I'm focusing upon is the growth of government, because today what we have is, as I said, this massive government here in Washington and at the state level, which is all pretty much an outgrowth of the progressive era and of the New Deal changes in particular, those that came about in 1937 and 1938, which I expect we'll get into later in this discussion.
Well, my point was that, and you're right, we did have the Alien and Sedition Act and other pieces of legislation that were, frankly, abhorrent, but they were eventually overturned, rejected, and gotten rid of. But
That's right.
But if you look at the Constitution, the way it's drafted, and the way, by and large, with those exceptions that were later overturned, we were a pretty free country, a pretty libertarian nation.
That's why people came here.
And we went essentially from a third world country to a world superpower in record time.
Absolutely. And the reason people came here was because they could breathe free and become all that they were capable of being. And that was, we didn't have the classes and the strict regulations that you find, the onerous conditions in other parts of the world. And so we've been a beacon to the rest of the world. We are a nation of nations, as we say.
Well, slowly but surely, over the course of the 20th century, the Constitution itself and its interpretation did change. And I'm always fascinated when I get into a debate and somebody says, well, we had to do that. We had to pass that law because there must have been something going on. And then I look at today's history, at what's going on, and I think, oh, I see how they did that. I'll give you an example. There was this pharmaceutical company, I think it was in Maryland, that was mixing specific drugs, and apparently they were tainted, and I don't know, 50 or 60 people actually died as the result of this. But they weren't so strictly regulated as the major pharmaceutical industries. And a country of 300 plus million, and pharmaceutical company like this that's been in business for decades, and there are hundreds of them, if not thousands of them across the country. This one screws up, and right away somebody goes, we got to write a law, and the federal government is now going to try to regulate them. And I think that's how we got where we're at. Some tragic event, which in the scope of history might be kind of small, but at the time it's been kind of blown out of proportion. And the next thing you know, the federal government or the state government, somebody's writing a law saying, well, we can't let that ever happen again.
Well, the whole issue of regulation is one that is very misunderstood. There are two basic kinds of regulations. There are, first of all, those that are necessary to flesh out more fully what our rights and obligations are vis-a-vis each other. The theory of rights that stands behind the Constitution comes from the common law of England. It's rooted in property and contract as the two most basic rights. And by property, John Locke meant lives, liberties, and estates. Your property in your life, your property in your liberty or your actions, and then the property you acquire in the world. And so a right violation occurs when someone takes something that belongs free and clear to you, your life, your liberty, your chattels or your movables, and your trespasses on your property, and so forth. And also, when someone breaches a contract, you also have your rights violated. So property and contract are the two basic rights from which all other rights are derived. And all of that is rooted in reason and, to some extent, custom as qualified by reason. And that developed over some 500 years with judges deciding cases or controversies brought before them in England and fleshing out the theory of rights in the course of doing so. But eventually you run out of principles of reason when you're trying to work out the theory of rights, and you have to turn to positive law. Regulations which define, for example, how much noise you can make before you interfere with your neighbor's right to quiet enjoyment, how much particulate matter you can waft into the air, how much risk you can put your neighbor to, what the remedies are for various violations of rights. I mean, how much is a life worth? How much is a limb worth? And, of course, all the regulations that are necessary for spelling out what our rights are once our rights are violated. And that's where all the due process stuff comes in. And so this is where regulation is very useful and important for fleshing out more fully the theory of rights. Then there is a second form of regulation, which is designed to redistribute from A to B. And that's regulation that prohibits A from doing what he otherwise has a right to do, or requires A to do something he has a right not to do for the benefit of B. And we have loads of that today in the modern regulatory state. Your hiring and firing is today all highly regulated, whereas it used to be this was all done at will.
All right, well, here's what I hate to do that right in mid-thought, but we have no choice because Brian is a greedy conservative libertarian and he wants his money, and we do that with these commercial breaks. So, ladies and gentlemen, if you'll just bear with us, Roger Pilon will be back. We'll finish that thought. It is the Gary Nolan Show, and it is the Zimmer Radio Network.